Landlords and tenants. Condition of the rented premises. In this section, we'll discuss 4 standards which apply to residential rental property: habitability, repair and deduct, liability for injury, and disclosure. These all have to do with the condition of rented residential premises. That means they don't have to do with commercial properties. Commercial is when you seek to rent a place for some sort of commerce or business. So your typical storefront, for example, would have different rules than residential rental property where you live. Habitability. All leases and rental agreements include an implied promise that the landlord will keep the premises in a habitable condition. What does that mean? Well, a habitable condition is a condition which people can actually live in safely and healthfully. And so even though your lease or your rental agreement might not specifically state in there that the landlord has a duty to do this, the court has said that there is a promise that is there, whether or not you like it, and the landlord, whether or not he signed into something, has to complete this promise, has to fulfill this promise to keep the premises in a condition which is livable. All rental units in California must satisfy certain conditions under the state law. This is not an exhaustive list. There have actually been many more different conditions which have been accepted under habitability and seen as habitability violations. But the ones here we'll just name off quickly. So weatherproof, waterproof, and rodent proof. You have mice running around, for example, in the house, and that is a habitability issue. Plumbing in the good condition, toilet, the wash basin, bathtub, and shower. So if you have a situation where the toilet is broken, sewage is backing up into the bathtub or into a sink, then that's a problem. Kitchen must have a sink in it. Hot water and heat. Natural light, electric power, and proper wiring. Smoke detectors must be in all multi-unit buildings. Door and window locks. Adequate garbage storage and removal. And a telephone jack. Like I said, there are more, and you by no means need to memorize this particular list. But just think about things within a home that if they were defective, or if they were broken, or if they were not working, would cause a problem and make it difficult to live in the house. And so that's what you want to think about when you think about habitability problems. Is this creating a condition where I can't, or the tenant can't live in a healthy way? So what if the landlord decides that they're not going to fix things, or they're not going to keep the premises in a habitable condition? Well, number one, they violated the law. However, what happens after that is really up to the tenant. The tenant has a couple of different options that we want to talk about. They can move out, they can withhold rent, they can call the building inspector, or they can sue the landlord. And then we'll also talk about a 5th option, which is that they can actually repair and deduct the cost of the repairs from their rent. Option 1 is move out. Even without notice, the tenant can move out when the landlord knows about, but fails to make needed repairs and furnish services. The 2 key pieces here are the words the landlord knows and that the landlord fails. The tenant must make sure that the landlord knows that there is a problem. The tenant can't just up and leave. The safest way to do this is to write a letter to the landlord stating the problems that are there and giving the landlord a reasonable amount of time to respond to those problems. And then the tenant should keep a copy of this letter for herself so that she can prove that she sent that off. The landlord may even be liable for relocation benefits if the tenants have to move in order for repairs to be made. These are very extreme circumstances, and this is something that the landlord must know about. If the landlord does not know that a condition exists, then they can't be held responsible for it. Option number 2 is to withhold the rent. This can be done in serious violations of the lease, of the clause of habitability. The implied warranty of habitability is what they call it. And this is when the landlord is knowingly in serious violation. So again, the landlord has to know about it. Same thing, write that letter. And the tenant can withhold the rent until the problem is fixed. Now, This is very important because the tenant must make sure that they have notified the landlord in writing about this problem. Because if they don't, and the landlord can turn around and claim that they did not know about it, the landlord can turn around and offer a 3-day notice to pay rent or quit to the tenant, saying you haven't paid rent on time. And then it would be the tenant's obligation to then use an affirmative defense of habitability problems at an unlawful detainer state. But not wanting to get too far into that situation, very important that the tenant make sure that the landlord know that they're complaining about a serious violation. The tenant may not withhold rent for just minor violations. So this has to be something very serious going on at the household. And the tenant may also not withhold rent if the tenant's the one who caused the problem or is contributing to it. To withhold, the tenant must do 3 things. Number 1, notify. Write that letter. Number 2, wait a reasonable amount of time, up to 35 days, before withholding the rent. So in the letter which is written to the landlord, it should state, here are the problems that are going on in my apartment, 1, 2, 3, 4. And these need to be fixed. Please make these repairs by January 1st. And if you fail to do so, then we will withhold rent. So 3 pieces of that letter: what's wrong, the time they have to do it by, and the consequence, letting them know if you don't do this, we are going to withhold rent. And then it's very important, and it's actually law in a couple different counties, couple different areas. In LA and Sacramento, you've got to put money into the money into a trust account. So even though you're not paying the rent to the landlord, you need to put the money into a trust account to prove that you're just not doing it because you don't want to pay your rent, but that there actually is a problem. On the other hand, even if it's not required, it's a very good practice, because if the landlord then turns around and decides to either fix things or decides to take you to court, then the tenant has the ability to say that they have all of the rent money, they just haven't been spending it, they haven't been paying it because of the habitability problem. Option number 3 is call the building inspector. And I've been told that this works better or worse depending on where you live. In some places it's difficult to get a building inspector out to, but definitely the Department of Public Works. They can order a landlord to make repairs, and the landlord will have 60 days to do that. If they don't do it, then the tenant can actually sue for their costs, an amount between $100 and $1,000, and their attorney's fees. The court can also order repairs, and the court may do this if the problem significantly affect the occupant's health and safety. Another option is the city or county. The city or county can bring a lawsuit, and they can even bring criminal charges against the landlord for habitability issues. Now, option number 4, sue the landlord. By the way, you can do one or all of these. So you can mix and match. They are not mutually exclusive. So you can be calling out the building inspectors and then turn around and decide to sue the landlord. Suing the landlord for discomfort, annoyance, emotional distress, the difference between the rent paid and the value of the substandard rental, for example. And what's going to happen is that the court is going to authorize what's called a receiver, and that's somebody to collect the rent and manage the property and supervise the repairs while they're being done. I shouldn't say the court is going to do that. The court can appoint a receiver in order to make all of these things happen. But depending on the lawsuit which you bring against the landlord, it may have different remedies. Now we get to tenants' right to repair and deduct. Repair and deduct is when you make necessary repairs, or you hire someone to make necessary repairs and you pay them for it, and then you deduct the cost of whatever you spent to make those repairs from the amount that you would have paid in rent. So for example, if your rent is $1,000, you end up making a repair that the landlord refuses to make, and that repair costs you $100, then at the next month's rent payment, you would just pay the $900. Now, very important that when you're doing this, you follow similar protocols as what we talked about withholding rent. Let the landlord know in writing. Write it down. Here are the problems, and then give them a deadline. If you do not respond and make these repairs by X date, then, number 3, what's going to happen? I will be exercising my right to repair and deduct. Okay, so very important to make sure that the landlord knows all of those steps. All of that is part of the knowledge element that needs to be shown. So if you do those things, the landlord fails to make the repair directly related to the habitability of the premises, and the tenant gives written or oral notice of the problem and a reasonable amount of time to cure. Now, this says oral here. Like I said, it's okay to do oral, much, much safer to do written, because whoever you gave that oral notice to can just turn around and say that was never said to me. And it's much more difficult to have that as your defense in court. So while you can tell them orally, always follow it up with a letter or start with a letter so that you have some sort of paper trail. Repairs can't cost more than 1 month's rent. And so if the repair being done is over $1,000, then clearly you can't deduct over $1,000 from $1,000 because you'll have a negative number. So the tenant wants to make sure that those repairs stay within their rental amount, and they can only use this remedy twice in a year. So if you've already done 2 repair and deducts within that year to take out $1,000 and not pay it to your landlord, then you can't use it again, and you may want to seek one of the other types of remedies to get some help. Additionally, the problem must not have been caused by the tenant or a guest of the tenant. Tearing down walls, and it's something that the tenant did, or setting the stove on fire through negligence, can arguably be the tenant's responsibility because it's a problem which they caused. Landlord's liability for injuries. A landlord may be liable if injuries were caused by a dangerous or defective condition, and the landlord knew about it, and the landlord failed to repair. So we're looking at 3 different things which have to be satisfied here. Again, there's the dangerous or defective condition. So you can think of, for example, a large deep pit in a backyard. That would be a dangerous or defective condition. But then the landlord has to know about it. So if it's an instance where erosion of a sudden storm caused this hole in the ground, then we don't have landlord notice, and the landlord didn't fail to repair because the landlord didn't know. However, if the landlord dug this big old hole, was trying to dig a well or something like that, and then failed to finish it and failed to make it safe, and so then the landlord knew that that problem was there and then failed to repair that problem, then the landlord may be liable. Now, this is important because they're not only liable for people who are their renters. They can be liable to anybody on their property. And even if you have something like a no trespassing sign up, or a gate or somewhere like that, if someone comes onto your property and gets hurt by a dangerous or defective condition, and you knew about it and you failed to repair it, then you may be liable as the landlord for that person's injuries. Landlord's unreasonable act facilitated a crime by another. That's another thing to think about. If, for example, there's no locks, there's inadequate lighting, and so it facilitated a crime. Or if another tenant or guest caused the damage or the injury, that's, for example, drug dealing on the property. That's something which the landlord may be liable for if you have, say, a multi-unit building, and they knew that this condition existed and this one tenant was making these problems, which caused a dangerous or defective condition, and they actually harmed another tenant because of that condition and because the landlord failed to do something about it. Disclosure. A couple of different things that the landlord must tell you. Utility arrangements. The landlord must disclose the nature of meter sharing situations before the tenant signed the lease, and it must be in a written agreement. So, for example, if you have a utility meter, which is saying how much power you use, for example, and you have it's a fourplex and you're all sharing this one meter, then the landlord must tell you the nature of how the costs are going to be split up when that power bill comes, because that meter is not going to tell you who spent which money. And so that needs to be put out there before the tenants sign the lease, and it must be in a written lease agreement. Lead paint hazards must also be disclosed. As long as, that should say lead paint, not lead paint. But of course, this is lead paint that the landlord knows of. They also have to provide a pamphlet on lead-based paint hazards. So if you've ever seen one of those attached to your lease, then you know why. Just to give information to the tenants. Now, the landlord is not required to actually seal the paint or remove the lead paint, but if someone gets poisoned, if someone actually gets harmed for it, then they may be liable. The only things that are completely exempt from this are post-1978 units, studios, short-term vacation rentals, single rooms rented in residences, houses for seniors or persons with disabilities, and that's unless a child under 6 lives there. It's kind of odd, though. You think there'd be more protections for seniors or persons with disabilities, but they have special exemptions. And then the sex offender database. The lease must include a paragraph about the Department of Justice's database of sex offenders and the communities where they live. If the landlord knows of someone who poses a risk and lives nearby, then they need to let the tenant know that. But again, this relies on whether or not the landlord knows that occurred, but if they do know about it, they have an obligation to let the tenant know that they may be at risk.